Everyone, my name is Dave Ramsey, and we're here for tonight's webinar on Community Association Clubs, Challenges and Perspectives. And the panel welcomes everybody and thanks everybody for joining tonight's presentation. The panel is made up of Ed Guttenplan, who of course is a certified public accountant and a principal in Wilkin and Guttenplan. Debbie Pasquarello, who is a community insurance and risk management specialist, known in short as CIRMS. An accreditation given by the Community Associations Institute to those insurance agents who specialize in community association insurance and meet certain criteria. And then Jen Lowiak and myself from the Greenbaum Rowe Law Firm. And we're here from, of course, the legal perspective. So let's get started. We've got a fair amount of material to go over. And I understand you're just going to be getting your view of the PowerPoint presentation in just a second. It'll be up in just a minute. But we're going to start with a general overview of the material and talk about why are we discussing this and why is this an important topic. We all know that many associations, and particularly age-restricted associations, have really become places where lifestyle is important. And lifestyle has been introduced by developers in many cases to communities and has developed on its own in many community associations. And of course, clubs are an important part of this lifestyle that are enjoyed in many of the age-restricted communities. In fact, they're a core part. They're a core part of the lifestyle that's enjoyed. And as a result, we see many associations that have numerous clubs, some having 50 to 100 clubs that include private, political, philanthropic, and recreational clubs. But they also bring about a risk with them. And sometimes it's not understood what that risk is. And one of the things we're going to talk about this evening is the need to define clubs and their relationship to the association. Are they really part of the association? Is the board responsible for them? Is the association responsible for them? Or are they standalone? And the real challenge here is to get a balance between minimizing the risk while not interfering with that important lifestyle that the clubs add to the association. So we have a number of different types of clubs, of course. We have those that are association initiated and are ceramics clubs, bocce clubs, or anything of that nature that are part of the association. We have local chapters of national organizations, Veterans of Foreign Wars, Deborah, political Democratic Republican clubs. Then we have independent clubs that may not be part of any national organization. You'll see Irish clubs, Italian American clubs, etc.
And Dave, actually, we should talk about some of the clubs we feel like Smoke Rise has a horse club, a
Right.
sailing club. What kind of clubs do you see? What's different?
Fishing club, bowling club, the
Garden
club, acting club, hiking club.
Yeah, you can see there's a list on your screen of just the variety of clubs that we routinely see. And if you just look through that list, travel social, horseback sailing, helping hands. Helping hands are those groups that sometimes will help residents in the community get to the doctor's office or get to someplace else. We'll talk about that a little bit. I think Debbie will have something to talk about with regard to those kinds of clubs. The bingo club, the knitting club, etc. Now, some of them you may say, well, what's the big deal? And probably from a liability point of view, there is no big deal.
You know, someone mentioned a garden club for the for medical marijuana. not in New Jersey, but it came up. What to do?
Well, see, even the gardening club can bring some risk with it. But you certainly can see hunting clubs. Can somebody get shot? Sure. Travel clubs. Where are they traveling to? What's the risk associated with those? We're going to be talking about that tonight. And even charitable clubs. You may say, well, what could possibly be the risk? Well, the risk is whether somebody might embezzle funds, whether they're properly accounting from a tax perspective, whether they're telling people that they can take a deduction because they made a contribution to the charitable club. They may or may not be able to. So those are all indicative of the kinds of issues that we see coming on.
Yeah, the one point I want to make about the list of clubs, too, and why it matters is because there's no one-size-fits-all, which we'll talk about later. Sometimes when you have travel clubs, a whole host of different issues will apply than, say, the bingo club and so on.
Okay, so now I'm going to turn it over to Jen, who's going to talk about, interestingly enough, constitutional issues.
Most of us think that the Constitution does not apply to private property. So the first question, the threshold question is, why does this matter in a discussion of clubs? Well, because most of the time the tensions that exist relate to First Amendment issues with clubs, membership of clubs, purpose of the clubs, what are these clubs gathering to talk about? All of these kinds of free speech issues that come up in an individual capacity become obviously much more important and more significant when we're talking about clubs that may have 50, sometimes hundreds of members on a property. And as Dave said earlier, it often comes up with the senior communities, the age-restricted communities that may have thousands of units. So very quickly, I want to tell you why the Constitution matters. The New Jersey Constitution provides every person may freely speak, write, publish his sentiments on all subjects, and be responsible for the abuse of that right, and no law shall be passed to restrain it. The two exceptions are for private property and for defamation. Under federal law, you would need state action or some kind of governmental involvement for the Constitution to apply to private property. In New Jersey, it's a very different situation because we had the New Jersey Supreme Court decision of Twin Rivers a few years ago. And in New Jersey, we've held that under certain circumstances, rights of free speech are balanced with the rights of the private property owners to regulate the property. I just want to take 1 second to go into the test that was used in Twin River, and there's a good point, and I just want to take a moment for that. It was called the three-pronged Schmid test. And what it does is it analyzes three things: the nature, purpose, and primary use of the property; second, the extent and nature of the public's invitation to the property; and finally, the purpose of the expressional activity on the property. And the reason that this matters is because in Twin Rivers, the decision said that associations are obligated to provide another outlet for this expression, to provide a time and a place and a manner for people to have their expressional activities. So the Schmid prongs come up in a couple of cases that we've seen since Twin Rivers. I won't go into the details of those cases, but I just want to circle around to say that one case had to do with information on a website and whether it was okay for the association to delete that information from a website that someone had posted, and that a homeowner went to the court and said, you know, they had a problem and this was their free speech. And so the court went through these Schmid points to come to that decision. Most recently, we had the Masterbrook Commons case, which dealt with an owner putting a sign in the window. And the important point there was they brought up Twin Rivers and took it and went through again the analysis, not quite as much as we'd liked with the time, place, and manner.
And the interesting thing about the Masterbrook case, Jen, is that the trial court had found that the owner had no right to put the sign in the window. The appellate division held that they did have a right to put it in the window, and it's been appealed to the Supreme Court, and because there was a split decision at the appellate division, the Supreme Court has taken the case. So we're going to hear more about that.
Right. So to sum this up, to get back to, well, why do we care, and what does this have to do with our everyday as professionals dealing with clubs on the property? The reason we care is because there is no black and white answer. Those associations that try to prohibit absolutely expressional activity, to try to involve themselves in commenting on which clubs are good and which clubs are bad and who should be a member and what kind of speech should happen, are going to find themselves having problems, particularly in New Jersey based on the law.
And Jen made this point, but I just want to emphasize that the right to freely associate with each other is part of the free speech rights that we talk about. So when you say, well, why are they talking about free speech? It's because that right of association comes along with the right of free speech.
You know, I'm glad you actually took a moment to mention that, because it's very important, and it does come up with the clubs all of the time. And we had, Dave and I just had a client of ours have a people of color group that meets, and there was an issue with whether that group excluded someone who wasn't of the same race. And the question was is that okay? Did it happen on the property? And there are no easy answers on that. We don't have to get into it here, but that's the kind of thing we see routinely. Okay, so you can pass this, Dave, because I already talked about the First Amendment, about how that applies. And then, we talked about state action, which means that, now just to reemphasize, in many, many states, state action means that the entity would have to be furthering a governmental purpose or availing itself of a court action or decision. Of course, as we all know on the phone, associations are not considered state actors at this time. So the reason New Jersey is unique is because of our Twin Rivers case and our law in general.
It's important to note, though, the court in Twin Rivers did say that it's still private property and it's not the same as a government. But having said that, the association still has to provide reasonable opportunity for that freedom of expression. Is that right, Jen?
That's absolutely right. And remember, the time, place, and manner comes up a lot. When we're advising our clients, we say repeatedly, it's not okay to say no signs, or no place to speak, or no place to meet. You must provide some kind of time, place, and manner to address the balance. Okay, finally, I just want to talk about some emerging trends, not necessarily law, but in our study, even nationally, of different cases in states. This is what we're seeing. We're seeing states begin to enact Bill of Rights language that within statutes that does make it applicable to community associations. So remember, I just said most times we're not talking about the Constitution automatically applying to community associations. Where states have now enacted statutes, it's a different story. Second point, dominant clubs as public accommodations. Now again, not the law, but in my research what I've seen is that public accommodations is subject to discrimination law at the state level. And it's very loose what's described as a public accommodation. And it's my guess, just my guess, that in the future we're going to see some of these associations, particularly the very large ones, that could qualify as a public accommodation as far as discrimination law goes. Other states' nonprofit eligibility for lower tax rates, that came up somewhere. They may require non-discrimination language, so you see it's coming in at the fringes. And increasing application of federal licensing for public performance, that's come up where, excuse me, any kind of performances, movies shown on these association properties are being treated as public and subject to licensing. And finally, all the courts constantly reference public policy and reasonableness. So in our work as practitioners, at the end of the day, when we're advising clients, we have to remember that we are always going to be subject to a balance between the rights of the private property owner and the rights of people to freely assemble and have free speech. So, okay, finally, why associations should care. Again, be careful about mandating what kind of members can be part of a club. People have a right to meet with their friends. And be careful about being fair to access to the clubhouse. That's a big one. If you reserve as a manager groups of time for different groups to meet in the clubhouse, there has to be an objective policy in place. You can't make a decision that one group is favorable to the association because you like what they have to say, and another group is just not as important. That will bring up a whole host of problems, including possibly Fair Housing Act issues. Voting, signage, publication, we've gone over that, making sure that you have criteria that's objective for the access to that. And clubs, finally, have the resources and size to challenge and change association restrictions. So where we may have individuals who fight for their right for free speech, the occasional person, as we move forward, we're going to see these clubs rise to size and dominance in communities, and they will be able to bring lawsuit or have a significant say.
And one of the countervailing factors that we're always concerned with is these clubs are using community association property, okay? And we'll talk a little bit about whether the clubs are dependent, independent, et cetera, but no matter whether they are dependent or independent, they're using your property, your association's property. The question then becomes, do you have to allow attendance at a club by everybody in the association? Well, clearly if you have an Italian-American club, if you have the Catholic Men's Club, the Jewish Men's Club, whatever it may be, they have a reason for only allowing people of a certain heritage or background. Now, people tend to say, well, that's discriminatory, and there's a sense that anything that discriminates is unlawful. That's not true. The fact of the matter is, if there is a legitimate reason to have people only of one group or class or category joining a club, you can do that. What you can't have is a pretext for racial, religious, or ancestry discrimination.
And against a protected class. And
right.
So it's an interesting part of this that people, it's a subtle point but very important.
So this is an issue that if you're dealing with this, you really need to talk to your attorney and you really need to discuss this issue because it's a subtle issue. Okay, we're going to talk a little bit now. I'm just going to broadly talk about managing risks because really Debbie and Ed are really going to get into the actual risks and talk about them. But we have concerns about legal liabilities, okay? Who's responsible if somebody's hurt? Insurance liabilities. Are you covered by a particular policy for a particular kind of accident or injury? Fiduciary responsibilities. Who's handling the money? Who's paying the taxes on it? What happens if the money disappears? Who's responsible for it? And perceived responsibilities for access, for activities. And what we mean by perceived responsibility is if you are the Sunnyside Homeowners Association and you have the Sunnyside Charitable Club, people are going to think that that's part of the association. So there's going to be a perception that the association is really vouching for that club. It may not be, but that's going to be the perception. And if that perception is clear enough, there may be legal liability. All right, so now we're going to just talk for a minute about legal issues. If there's a claim, somebody gets hurt, who gets sued? If the club is unincorporated, who's liable? Well, it may very well be the people who are running the club, the officers, and so on. If there's violations of state and federal law, well, you may say, well, what kind of state and federal laws could we be violating? Well, alcohol laws. A lot of times clubs run events, they run parties, they serve alcohol. They don't always have the necessary licenses to deal with that. A lot of associations will have bingo and other types of 50-50 raffles, etc. Sometimes they go out and they get the licenses for that. Sometimes they don't. There's copyright violations. We particularly have seen this lately in the last year or two where music is being played, whether by a band or just recorded music, and there's a fee being charged for an event. That is a copyright violation if there's not a fee being paid to the license holder, and that's a potential liability for the association. Does the club use, and we mentioned this already, does the club use the name of the association in its title? If it does, there's going to be a perception that that is an association-sanctioned club, and therefore the association is responsible. And what about off-site activities? Well, it's going to depend on where off-site, and again, Deb will talk about that.
Dave, before you go on, maybe spend a moment on the alcohol, because that comes up a lot.
Sure. You know, it almost seems, and we joke about this, it almost seems sometimes the reason for some of these clubs is to have events at which alcohol is served, or to have parties or whatever. And sometimes those parties have a ticket price that goes along with them. And the ABC basically says if you have a ticket price and alcohol is included in the event, in other words, you don't pay per drink, it's still paying for the alcohol, and you must have a liquor license for that. Then there's the situation where people bring their own. Yes, you can do that. You can have bring your own liquor, but that only applies to beer and wine. It does not apply to hard liquor. Now, there are other types of licenses that can be gotten, event licenses and so on. Caterers can have a license, but very often this is ignored totally. And our concern always is, yeah, people get away with this all the time, and no, the ABC isn't looking to come down on age-restricted communities and their liquor issues. But once an accident occurs, will people now go back and say, did you have a license for this? You bet. And if you didn't have a license, is that going to go against you, the club, the association, in terms of the liability? You bet. Very recent case out of Bergen County, just in the last couple of weeks. This was a landlord situation where an apartment building allowed a party to be held. It wasn't even the landlord's party. Somebody who was 20 years old was served alcohol. They got into a car accident. They hurt somebody. A $7.1 million judgment was entered against the landlord. That could happen to an association.
So watch out, golf club.
That could happen. It doesn't happen often, but when it does, the hit can be really significant. Okay, at this point, I'm going to turn it over to Ed.
Good evening, everyone. The long-awaited accounting section is about to start, followed by Debbie, who's going to talk about the insurance. And one of the things I want to point out is between Debbie and I, we kind of split the risk issue. And I say that because the accountant deals with, or the accounting deals with tax and financial risks. And then there are the legal insured risks. So not all of the risks that you will encounter are going to be insured. Some of the risks are tax return, tax filing risks, and fiscal risks that you may not be protected by through insurance. So just to go through the potential financial risks to give you an overview of what we're talking about and what they are. And again, some of these risks are not insured risks, and Debbie will talk about that further. There's loss or theft of funds. There are issues with incorrect record keeping, not really understanding what the committees are doing or the clubs are doing. Expenditures for inappropriate purposes, and that could range. Your imagination is the only limitation. It could be for political contributions. It could be for just inappropriate expenditures that a prudent board member or a prudent board wouldn't authorize, that at an individual level is controlling the finances may be more inclined to cover. I mentioned political contributions. There are sales tax, sales and use tax issues, and federal tax issues that present itself to the association. If the club is using the association's federal ID number, then there's every right of New Jersey and the federal government to come after the association for noncompliance by what may be a club operating on its own but using the association's ID number. And there's a broad range of issues here. It's not just income taxes, it's sales tax, it's whether you have independent contractors functioning or reporting as independent contractors and you're giving them a 1099 versus a W-2. There is a whole gamut of issues with respect to that classification. There's also the issue of the dependence on a single volunteer for custody of funds. And that manifests itself in what we see sometimes where a particular club member has the checkbook for their club. Nobody else has access to it, and you're dependent upon that volunteer who has the control of the funds. Not only that, but you're dependent upon that volunteer for maintaining the records of the association, the financial records. If, for some reason, that volunteer gets angry, decides to leave, moves on, and doesn't properly provide for transition of their accounting records, obviously that puts the association in a difficult situation. Also, one item that's not on this list, and a lot of this we learn from the problems we see and the things that manifest itself over time, but there is also the possibility that members of a club could be personally enriched by the activities of the club without anybody else knowing it. And a typical example of that, or the example that brought this to life, was a travel club where the club, the chairs of the travel club were personally benefiting from the bookings that the travel club was undertaking, and were either getting commissions or free rooms and so on. And that's an issue that is sort of under the radar, but I think it's something you should be aware of. The financial reporting implications and controls, I think you get the sense from this group that the board shouldn't turn a blind eye towards groups running enterprises. And typically we see that history in many of the active adult communities that have been around a while, this issue of club risks has not been adequately addressed in the past. Now the board, all of a sudden, through some of these programs like the one we're doing right now and other programs that have been put on the issue of risks in clubs are starting to see that now this is an issue. And we can't turn, the board should not be turning a blind eye or rely on past history as a justification for not doing anything. I think it's all the more reason for the boards to have the courage to adopt best practices when it comes to how they treat their clubs and how they hold them accountable for what goes on. The club activities, other than the independent clubs or the national organization clubs, their financial activity has to be included in the books and records. Sorry, it should be included in the books and records of the association and be reported in the annual financial statement. So if you have a club that's under the auspices of the association, their activity needs to be included in the annual financial statements. At a minimum with the annual financial statements, and at a minimum with the completion of the association's income tax returns, and if there are sales tax returns, there may be implications to sales tax filing. But they must be included. If they're using the association's federal ID number, their financial activity needs to be included in the reporting by the association. And once that becomes the mandate of the association, the board is then responsible to ensure that that reporting and the controls are adequate for that purpose.
Sometimes then what we see, of course, is that the association's tax ID number is used even without its knowledge, because there's no corporate entity or any other type of entity that has its own tax ID number, so they use one that's most convenient.
Right. That's a good point. Many of them somehow get the association's federal ID number, and somehow the bank allows them to open up an account, which we can't figure out. And particularly with some of the older active adult communities that have been around a long time, it's a mystery as to how that happened, but it happened. Somewhere along the way, somebody got the ID number, maybe they gave the number to somebody else, and the bank, for some reason, was willing to open up an association account with that ID number with just that individual going to the bank. So it's a good point, and it needs to be policed by the board because, again, if they're using the ID number of the association's on the hook. Independent clubs and clubs operating under a national organization obviously are not required to be included in the financial statements or reporting of the association, but you need to be clear to distinguish who those are, particularly with respect to independent clubs, making sure it's clear what is an independent club and what is a club under the association's auspices. Other financial reporting implications and controls. The associations are likely to be held responsible, as I said, for the club's financial reporting, for the fiscal control and custody of the funds that are in the hands of the club. Unit owners who have contributed dues or other funds to a club, if those are somehow misappropriated, there's a good chance they will look to the association to be made whole for what's missing. There are tax reporting and filing requirements, and obviously failure in any of those areas is could result in the association being held responsible. The question often comes up, how do we then create an oversight over these activities to make sure that they're happening? And how do we have oversight over the receipts and disbursements of the club so that we know that they're for the appropriate purposes, that they're paying vendors appropriately, and there's the proper accountability? And the typical ways that we see it are either through some kind of internal audit function by the board, or a select committee of the board or the finance committee that has the responsibility for some internal audit function, which could be just getting the checkbooks or the reporting that's done by the clubs if they're reporting in a more informal way. There's actual reporting to the board. Some communities require their clubs to submit annually their budget in advance and then provide budget versus actual activity for that club during the year on a monthly or quarterly basis. The least effective, but it is a process, is that in connection with the annual audit or annually, the club needs to submit to the board a record of their year's worth of receipts and disbursements. And as I just said, that's the least effective because it's after the fact. It's a whole year has elapsed, and it's hard to really do anything when you're in December and something happened in February that you weren't particularly comfortable with. And then intermixed in this whole issue is what's the role of the managing agent? Should the managing agent be controlling the receipts and disbursements of funds? Should the managing agent really be the conduit through which this reporting takes place, or is it independent of the managing agent, and is it done just by volunteers and done once a year in connection with the audit? And it obviously depends on whether you have a managing agent, whether you're self-managed, the size of your community, and so on, and the willingness of the managing agent to become involved in this process, which includes a mountain of details and small and a large volume of transactions that they may not be equipped for. It's a large volume of transactions that are those where someone comes and says, I need a check tomorrow to pay the DJ, and sometimes the managing agents need more lead time to be able to produce checks than on demand, as it often happens. Income taxes for independent clubs, and again, we're talking about the clubs that are operating independently, because the clubs that are operating under the auspices of the association fall into the requirements of a typical association's accounting and reporting. But clubs that are independent, they may be subject to tax on their income, on dues and fees, outside fundraising activities, and they have to. There are more stringent guidelines because they are operating independently and are required to meet certain IRS requirements for being able to operate as an independent club, as a nonprofit club or social club, and have tax-exempt status. And as it says here, the IRS has requirements to qualify as a social club. You have to apply for the status. You must annually file a Form 990 or 990EZ for the activities of that independent club. And to the extent that the clubs are not independent, obviously, as I said before, the association's responsible. The biggest challenge is that the associations have clubs which they can't control. They're not willing to comply with the association's policies, so they become independent clubs, and they fail to follow these requirements to be an independent club, and then they fall into this gray area of what are they and where's the exposure and who's responsible.
Okay, how difficult is it to fill out that Form 990 or 990EZ? Is it a big deal?
The 990EZ, which is for the annual filing, is very simple. It's a one-page kind of card thing you send in. It's a little more involved to file for the exemption to be considered a club. That's a lengthy questionnaire kind of thing that gets filled out. But that begs a whole number of other questions, which is, do we separately incorporate? Do we have separate insurance? Do we have a separate board to manage our little separate nonprofit organization? And how do we make sure that it's clear where the lines of liability lie between the independent club and the association?
Ed, do you think it's enough for the association to maintain a checklist that these independent clubs are meeting these things you're saying, or do they have to go further?
That's a great idea, and I know we've done this together. We've recommended have a policy, have a checklist of what your expectation is for each of these types of clubs. If an independent club is unwilling to follow the checklist and do what the board feels are the appropriate processes to limit their risk, then they shouldn't be allowed to operate within on the association's common property and put the association at risk. The last area that I just want to go over, it relates to sales tax, which is sort of it doesn't normally fall in the radar, but I point it out because with respect to clubs, it's sometimes much more of an issue than anybody expects. What we need to look at is whether items purchased by the club are subject to sales tax. There are specific rules with respect to purchasing items that would normally be subject to sales tax, for which sales tax isn't paid, and then the association is responsible for a use tax. And just simply what that means is if you buy from an out-of-state vendor that doesn't collect sales tax and remit it to New Jersey, to the extent you have purchased something out-of-state with no sales tax, or even in-state where no sales tax was collected but should have, the association will be responsible for what's called a use tax, which is the New Jersey Division of Taxation's way of collecting sales tax for items for which the vendor has not collected the sales tax. So the association could be on the hook for that. Particularly where you have volunteers who may not be seasoned in all of these financial issues, and they're managing the checkbook of the club, it puts the association more at risk because they're ill-prepared to identify what might be a sales tax issue or an income tax issue. So it's important for the clubs to be aware of and comply with these regulations, and it's important for the board to make sure that there is the wisdom and business savvy of those involved in the financial affairs of the club to be able to identify it. And lastly, all of this applies to the independent clubs as well, but the liability for those, for the moment, we're assuming lies with the independent club. It's the clubs under the auspices of the association which present the biggest risks and require that the association have some level of oversight so they can identify where this might be an issue. Lastly, just one other comment with respect to those that are getting 1099s, independent contractors who are performing services, or entertainers that are doing things for these clubs. And there's a myriad of things that could involve people who are performing services for the community, which they're functioning not as employees, and I think Debbie's going to talk to this issue. There's a different threshold for whether you're subject to workers' comp insurance versus whether you are deemed to be an employee, a W-2 employee, part-time employee versus an independent contractor 1099 person. The board and those responsible, or the board is actually responsible for making sure if there is a payroll tax issue that they address the payroll tax issue. And they need to understand what monies are being paid to individuals who are performing services for the club, so that they know that the appropriate method of filing and treating them for payroll tax purposes is appropriate. And we generally don't rely on the individual to tell us that. We've got to really make sure they're telling us the right answer as to how they need to be treated for payroll tax purposes. So that's the summary of my end of things. I'll now turn it over to the wise and wonderful Debbie.
Hello, everyone. I want to talk to you about the exciting topic of insurance. I know it's everyone's favorite. I can tell you that when these community association policies were originally written, they were written with the thought in mind that the community association's amenities were there to be used by the owners and guests, and it was a very traditional risk. Over the years, active adult communities have evolved, and other types of active, even if they're not adult communities, that now borderline on resort living. There's all sorts of things going on that never used to go on before. In the early days, there would be a clubhouse with cards and billiards and crafts and the bocce and shuffleboard and things like that, and now they're jet-setting around the world, and they're taking bus trips to Canada, and they're going out on all sorts of events. And things are not confined to the association anymore, which they used to be. Now they're looking to be protected, even as they extend off premises and go do many other things. Some of the concerns that we have are, which activities will the insurance company cover? Oops, sorry, I'm supposed to push a button. Okay, which ones are covered? Which ones can we get insurance for? which ones can't we get insurance for, and who will be covered and who won't. I have somebody else who's going to handle my clicker. I think I was out of reach.
We passed the clicker off.
I think I was out of reach of clicker. Okay, so we're going to look at, one of the things that's very important is that you should speak to the insurance agent on the account, have them do some research if they're not familiar with it, to find out what types of activities would be covered on the policies that you're working with. Different insurance companies look at it differently. One of the things that we like to do is, where we can't get insurance for a trip, we like to build a firewall around it. My page is up. No, I didn't. Okay, we want to help the associations in risk management fashion to build a protective firewall around the association to protect yourself from trips that aren't covered. Okay, do you know that all policies have an exclusion for anything to do with an aircraft? How do most people go on those trips? They also have an exclusion for non-owned watercraft. So that would be anytime you step foot on a boat, whether you do the Circle Line cruise or your fishing club does a fishing tournament, offshore fishing or even freshwater fishing on a boat. If they pay any type of a boat, we've got those issues that come up. When we do the bus trips, they're okay. We do have non-owned and hired auto on the bus trip. So we do have coverage for that, but once they go over into Canada, we could have a problem with the actual territory that's on the policy. Some of the things that we can do to help an association is, number one, find alternate insurance for the items. For the boat trips, if they're going to stay in international, in U.S. waters, we can get a special events policy that covers for that non-owned watercraft exposure, but not on a cruise ship. Once it crosses into international waters, we don't have the ability to get insurance for the association. It may be available through a surplus lines company, but the price would be prohibitive. The firewalls that we would build around the association is transfer the sponsorship of those trips. Have the actual travel agency sponsor the trip, not the association. How do you do that? Let them come in and present the trip to the groups. Let them advertise in your newsletter or on your websites and on your TV channels. Sell them advertising for $1. Let them sponsor the trip. Let them advertise the trip. Don't let the association clubs collect payments for the trips. Have the payments go directly to the travel agency so that there's one less connection from the association to the actual trip. The association can get the travel agency to add them as an additional insured to their policy. Now, they may have similar exclusions to your policy, but let their policy be the first line of defense where possible. Waivers. You can get every participant on a trip, I'm talking every person, whether it be a resident or a guest, to sign a waiver. Now, I'm going to leave that up to Dave and Jen to explain what type of a waiver you could definitely get. But if people sign a waiver that states that they know there's no insurance provided by the association for this trip, it may be just enough to make people not sue.
Okay? Yeah, I think that goes to the issue of people being aware of the fact that the association is expressly disclaiming liability or sponsorship, to your earlier point of pushing off that sponsorship. So the waiver is effective that way.
Right. Okay, one of the other things that I really like is we've worked with some associations to get the travel agency to include in the price of the trip a travel accident policy for every participant. And we recommend that it's $1 million per participant. And let me just tell you that if there is an accident on a trip and people are killed on the trip, we know of some incidences where that has happened, if the family members automatically get $1 million for mom and $1 million for dad because they perished on a trip, it may be enough for them not to decide they want to go through the burden or the emotional stress of going through a lawsuit to try to get money to make themselves feel more like they're whole. You can never bring mom and dad back, but if the $1 million per mom and per dad is paid into the estate, I think that it can help to prevent them from suing the association. Now, I've gone back into associations that I've worked with, and they had a brochure tree right in the lobby of all the different trips, and they were all advertised and promoted by the travel agency, and they put right across the brochure, $1 million travel accident policy included in the premium or in the price of the trip. And they're actually using it now as a sales tool. So I think everybody liked the idea. It's just, to me, one more thought on how do you make someone whole without them coming and suing you. We talked about certain clubs being separate. Well, there are clubs that should be incorporated, that should be not part of the sanctioned clubs, and it depends on what their activities are, the extent of it. Generally, we find Italian-American and Irish-American and people that are organizations like that that really have extensive trips, that they want to manage their own money, they want to do their own fundraising and things. They should then, if they're going to be independent and incorporate, they need to go ahead and get their own insurance for a club. It's not that expensive to do it. It's a very good idea to do it.
Deb, if I can interrupt here, this has come up recently for a couple of our communities that have a dozen or so clubs, and they've wanted to actually purchase a policy and name each of the clubs in the policy. No, we're not talking committees, we're talking clubs.
Yes.
Name each of the clubs in the policies, and it wasn't even that these clubs traveled. They just didn't want to have to deal with, to Ed's earlier point, going through and checking every single club's compliance. So what do you think about that?
We did find one insurance company that was willing to do a blanket clubs policy, and you list all of the clubs, all of their activities, and how many they have per year, and things like how many people attend the different events. We didn't actually ever wind up doing that, because if they wind up going that separate route, are they getting the tax implications and things like that? I do know that some of the larger communities have mandated that most of their clubs become independent and do their own thing. One of the things that I found interesting when we first started doing the research was the wide-eyed managers looking around at their recreation directors at these active adult communities and said, you're collecting the travel money and putting it in our account, and you're dispersing. You're doing that? Oh my God, what are you doing? We didn't even know you were doing that. So it is amazing to see, and we've met with other groups that have been around so long that the clubs are doing whatever they want, and a lot of the board members aren't even aware of it. We're working with one now that we're trying to help them gingerly implement the rules so that they're not lynched. Okay, we want to keep the community in the community. We don't want to tell people you can't do this or you can't do that. But you also have to protect the association. You have to make sure that they know what they're opening themselves up for as far as liability suits and things like that. Now, I did get a little bit out of order here. I apologize. The bus trips. We do have the hired auto coverage. It will cover it. The bus, everybody says, well, the bus company has insurance. Yes, they do. If that bus turns over on the parkway, and we know they tend to do that sometimes, the bus company's policy will defend the bus, and the association's policy will defend the association. If there's a travel agency involved, they'll defend the travel agency. They may also defend the association if they've been named on their policy. But basically, that is what's going to be covered. Now, when we did the hired auto, the exposures were originally thought to be to go to see a New York play, or to go to Atlantic City, or to go out to Pennsylvania Dutch country or something like that. They weren't really planning on trips out to Bronson or up to Canada. Those are, they charge about $100 a year for this coverage, so they certainly were never planning for cross-country trips. on such a regular basis. So it does have coverage. Be careful about where you're going and what you're doing. We talked about fishing and charter boats. Once you set foot on a boat, you don't have any coverage. It's very, very scary, but if you do something with a boat or a fishing charter, know that if it's going to stay in U.S. waters, you can get a special event policy that doesn't have the same exclusion that every package policy has for non-owned watercraft. The airplane trips are another story. They're excluded. They're excluded on your primary liability. I've never seen a policy that includes them. They're excluded on the umbrella policy. I know we can't. I visited with a community that their prior agent told them it was covered on the umbrella. I went to the umbrella carrier. They gave us the actual exclusion for any aircraft. So that is not going to be covered. Those are things that you just need to know. And a lot of communities have been running these trips for a very long time and not realizing if something happens and they're sued as one of the plaintiffs, they're not going to be, one of the defendants, I'm sorry. I know you would correct me there. That if they're sued, they're not going to have insurance. Okay. We talked again about don't sponsor the trip, have the travel agent add you as an additional insured, have them sign waivers. See, I did the whole thing off my summary. Okay, let's go into the next subject. Lessons and instructors, entertainers. That's all a huge area of exposure. When active adult communities especially are looking for things to constantly be happening at their clubhouse, they're looking for people to come in and speak about something as simple as finances. They're looking for someone to come in and teach yoga or line dancing. They're looking for all sorts of lessons and instructions. And then they're also looking for entertainment. Do they have a choir come in at Christmas? Do they have DJs come in? We had a claim where a woman tripped over the cord of a DJ at a Christmas party or New Year's Eve party, and she broke her hip. Well, that DJ didn't have any insurance, so the association's insurance took the brunt of the claim. So one of the biggest things that we find is that you're not going to find too many entertainers that do have insurance. If they have liability, they don't have workers' comp. So that becomes a major issue. What do you do in that case? Workers' comp, they could potentially be picked up on the association's policy if they become an uninsured subcontractor. So that can be an issue. We'll go into that in a little more detail. Your next exposure that we find at some of the active adults is helping hands groups. Now, helping hands would be those that may drive someone to the doctors and things like that. This is a group that absolutely has to be independent. There's no way they can be part of the association. I don't know of any insurance company that's willing to pick up that exposure. When you have residents driving other residents, you don't know their age, their driving ability, or their health. So that's an issue.
It comes up in almost every community where they have these helping hands groups.
Right.
That's
right. We try to. That has to be something separate. It's too big of an exposure. Okay. We have the sports activities. We have a lot of different groups that want to have organized sports and leagues and things. Just know that most policies have exclusions for organized sports activities. Maybe the medical payments don't apply, or they may have a full exclusion for it. If you have sports teams, you may want to look into getting an accident policy for those folks if they're injured. And one of the things I want to tell you about clubs that are covered or not covered, when we say a club is covered and included on the package policy for the association, that's if the club is sued. That doesn't make it a giant accident policy for everyone who participates in an activity. Okay, if the club is sued and the association is sued and it's a club that's sanctioned, the association's policy is going to defend both. If someone is just injured at an activity of the club, they should go through their health insurance, their medical insurance, and go through the normal channels before attempting to collect from the association. So that would be my last issue on that.
Okay, well, so now we want to turn to some, what do you do? And we've given you this story of horrors for the last 50 minutes, and you probably need to know what do you do at this point in time. Not one size fits all, that's obvious. What we have tried, and again, this is just a recommendation and it's a work in progress as we go, one of the things that we've tried to do is set up and separate these clubs. With large communities that may have dozens or maybe even up to 100 different clubs, we have set some criteria working with the board to have smaller clubs. You might do it by numbers, maybe 40 members or less, clubs that don't have bank accounts of their own, that are rather benign, if you will. They do some small crafts or their activities on site, and have that exist under the arm, the activities arm of the association, where other clubs, the ones that are larger, that do take the trips, that have the big bank accounts, make it clear that those are in fact independent, larger clubs. And that's one way to begin to set it up, and then, as Ed and I were mentioning earlier, set up a checklist where we're checking and we're keeping administratively tabs on what's going on with these clubs without having to dig a whole lot deeper on every point.
And we understand that if you're dealing with an established association, maybe these clubs have been in effect for 10, 15, or more years, there's a sense of entitlement. These clubs really feel like they have their own power, their own rights, their own ability to do things, and they will push back. They don't like when the association starts to impose requirements. But usually if you do a good education program, while you'll still get some grumbling about it, eventually they will come into compliance, and once a year goes by, everything kind of just falls into the norm, everybody's going along fine, and these things are just being done. So let's just go to the next slide here. One thing we would recommend is generally don't allow the use of the community name in the name of the independent club. Again, it's just a perception that the association is running the club at that point. Obtain an annual certification that confirms that the independent clubs are separately incorporated, they have their own bylaws, they file a tax return, they have a tax ID number, and they maintain some kind of minimum liability insurance. You don't need to look at each of these documents, but at least get them to self-certify that to you. So you've done some due diligence, and you've said, we've checked this out, they're using our property, and they meet these minimum criteria. Require, when they're on association property, that they comply with the law. That means alcohol licenses, bingo licenses, et cetera, et cetera. Now, one of the people who wrote in a question while we were doing this asked, what about if the alcohol is complimentary? Well, it depends. If the alcohol was part of the admission price, in other words, you charge $25 for a dinner dance or something of that nature, and that included an open bar for an hour, those people paid for the alcohol. One way to avoid that is if you have a club and you have a budget, and in that budget you have a line item for alcohol, and the club members all pay at the beginning of the year $25 for club dues. The ABC does not consider that selling alcohol.
And the reason is because it can't be confused with fundraising activities that could go on for political functions that aren't private.
Right. And by the way, if anybody else has any other questions, please type them in. There's a spot on the box for you to put them in. We'll be happy to try to answer any other questions that come up.
Dave, on the issue of the liquor license and the ABC control, can you talk to how that may influence the legal liability if there's a problem?
Absolutely. Absolutely. It's a great point. As I said before, the issue never really comes up until somebody has an accident. And then all of a sudden, lawyers get involved, and they look to start pointing fingers. And of course, one of the fingers that's going to be pointed is at the club, at the association, et cetera. Now you get to trial. And of course, a good attorney is going to find out you didn't have a license for this. The attorney is going to try to convince the jury that because you didn't have a license, you were reckless in conducting this particular event, and is going to try to convince the jury that there should be a penalty applied in the judgment so that additional monies are given to the plaintiff for your ignoring the law. That kind of judgment or that additional amount of money that is granted by a jury is not covered by insurance. In fact, New Jersey law doesn't allow it to be covered by insurance. So that's why the license issue is so important. And I know people will always say, well, we've been doing this for 20 years. We've never been caught yet. Why should we worry about it now? The answer is it's probably because you didn't have an accident. Once you have that accident, and I mentioned that $7 million case out of Bergen County, that's when you're going to get hit, and you could literally bankrupt the association.
I think one place that we have to jump in as one of our concluding thoughts is that we don't want to chill participation. We've talked about that many times. Clubs often are the best parts of these communities and what they contribute. And so of all these things we've gone through, it's more about the association taking time yearly, quarterly to educate the community on the liabilities and the risks, and to not get involved, again, with trying to restrict certain clubs' messages or purposes or who should be members. And we run into that all the time. Yesterday I heard about a resolution restricting religious activities, and the other day we had something else very similar. It comes up an awful lot, and it's about maintaining a balance.
Ed, Deb, anything to add?
No.
Okay. Did we get any more questions? Okay. Well, while we're checking on questions, we really think that the guidance we've tried to give you, if you undertake it and there is transparency in what you're doing, you're going to help avoid risk. And really, what you're trying to do is, board members and you are managers, you have a fiduciary duty to your association. And a lot of times board members forget that. They have a duty to protect the association. Yes, they want to promote the club and they want to promote the lifestyle, but they also want to protect that entity that they are the guardians of as trustees.
Dave, there's another question that came in regarding the liquor license, and we all suspect that this is a hot topic because it's one of those sleeper issues. But the question is, when you talk about a liquor license, are you talking about a general liquor license? Are you talking about a special use license? How do we navigate what we need in the way of a license or permit to serve alcohol?
I spoke a lot with ABC on this topic, and aside from the very few, maybe very large associations that even have a restaurant or something, very few general licenses will be given out to private associations. So the way it works are there's social event licenses if you're holding a party on New Year's Eve, or the second option is to hire a caterer that's licensed, that has that general license, go about it that way, or include it as a line item. But it's almost unheard of for the association to just hold a general liquor license. That's how I understand it.
And most associations don't want to do that, frankly, because there's certain liabilities that go along with that. And the only other thing I would say, and Debbie, if you want to comment on this, is make sure you have host liquor liability insurance.
Well, almost all the community association policies have host liquor liability, but if you're running a really big event and you do get the one-day permit, ask your agent if they recommend a special events policy that would give you extended liquor coverage. So definitely check with your agent if you're running a function you're serving alcohol. The general small events that are BYOB, you're going to have your host liquor coverage for. So.
Or maybe don't ask, don't tell.
Okay.
Another question that come in about availability of the slides and looking at the PowerPoint, and it will be available on our website, on the WGCPAS website, or any of the speakers, I'm sure, will be happy to provide information, but it will be posted on the Wilkin and Guttenplan website if you want to view it.
Okay, one of the other questions that came in is, should clubs the independent clubs get their own directors and officers liability? When an independent club is formed, if they have a board, which most of them will, they should definitely look into getting a directors and officers policy. Of course, everything is a matter of what you can afford. Hopefully you can afford all the best coverages, but sometimes that does make the club's budget go a little bit crazy. But we do recommend you look into it.
One of the points I think we should make about insurance is very often the cost that is debilitating is the cost of the defense. Even if you're an innocent party, if you're sued, if you don't have insurance, you're going to have your own attorney defend the club or the officers of the club, etc. And that is going to be very expensive. So at the end of the day, you could win the battle but lose the war because legal fees can be in the hundreds of thousands of dollars.
Right. It's definitely the best reason to buy insurance is for your defense costs.
A question for you, Dave. These typical policies, let's say that a D&O for an independent club is $1,000, and the members of the independent club say, you know what, we're going to fly blind, we're going to fly naked, we're not going to get the insurance, but we're going to still operate as an independent club. How should the association respond to that?
Well, I think the important policy, and Debbie can certainly add in here, is the liability policy.
Mm-hmm.
You know, the D&O policy would be nice. I would see that as somewhat of an added benefit, but one that I would not necessarily recommend to an association that they mandate the D&O policy. However, having said that, we often say as we talk to people and when we give these presentations, understand we're looking to protect you as an individual. You're in a retirement community. You gained your assets over your life. You're looking to enjoy those assets as you go into the sunset of your life. The last thing you want to do is be sued and lose all of those assets. So yeah, the insurance may be viewed as somewhat, quote, expensive, but when you spread that out among all your club members, and particularly when we're talking about independent clubs, 50 members, 100 members, et cetera, the cost is not that significant that you should just dismiss it without giving it some serious thought.
Exactly. You know what? Even if you buy the special events policies for the big events, minimum premiums on a special event policy is $300. So it's really money well spent. If you look at it, you know, hindsight, if you had a claim, you're really going to be happy you spent that money.
Okay. Well, I think we've concluded our hour here. Hopefully you found it interesting. Hopefully we opened your eyes to some issues and to some solutions.
And please feel free to contact any of us for further questions.
Absolutely. All this information is right on your screen right now with all of our contact information.
Thank you.
Thank you.